that difference between 400 and 500 a week, and they can sue for the difference, the 100. If they just say, no, we don't accept that, and we're going to sue you for a loss of 500 a week, then a court may well find that you had an option to reduce those damages to only 100 a week, you didn't take it. It all depends on what's reasonable. A party only needs to act reasonably to mitigate their losses, and it may not be always seen as reasonable to recontract with a party who has just breached their contractual obligations. Be careful with termination. Under some contracts, there will be specific rights when you can terminate, and under others, you can only terminate under the common law. Often, or sometimes it is the case that if you terminate under a contractual provision, let's just say it gives you the right to terminate for any breach, no matter how minor, if it's not corrected within 10 days, then that may limit your damages that you can obtain. You may not be able to get those damages for all the future performance of the contract, because that termination you've done under the contract may not reflect a similar right to terminate a common law, and it may only be that right to terminate a common law that gives you that right to those future losses. It's a very difficult area, and I don't expect anyone has just walked away from that last paragraph I've just said and thought, well, I fully understand this now. I know when I can and can't terminate. What I want to say is just that be aware that it's complex, and the decisions you make can have a great impact on what damages you get, so do seek legal advice. Okay, I'm going to quickly talk about new contracts, and I think that a lot of what I've talked about past contracts will help inform you about the new contracts in any event. So if the new contracts, or if it more takes the form of future supplies under an existing contract, obviously notify of any delays, put these notifications on your website, quote forms, call up your customers, make sure any public documents that you've released are not misleading. If you've got a brochure sitting out somewhere that refers to commitments that you can no longer meet, then you might need to put a sticker on each one of those brochures alerting to that effect. You may need to remove the brochures. You'll know what documents you have out there. If perhaps you had an existing tender response or quote that needs to now be withdrawn, just be on top of those sorts of things, because until you withdraw them, they can quite often be a standing offer that's open for acceptance. Where there will be extra costs, and even if you have a contractual right to those, just do your best to predict what they may be. Now, you won't know, say it's a shipment, which shipments all of a sudden are going to be detained somewhere, or which are going to be unloaded and transshipped because a port is closed. And I think we're probably at a stage now where that's looking less and less likely that the dramatic impact on supply chains will occur. But even so, you can say to your customers, if it's a big material amount, a lot of containers, for instance, you can say, look, we've given you the best estimate we can based on this. Just as a guide, if this needed to be transshipped from a Chinese port to a Korean port, and then it sat there for 2 weeks, that on its own would cost this extra amount, just to give the customer a bit of a guide about how big a risk it is they're taking. Obviously, have a look at what security you have in place for if you're a supplier for performance of the customer's payments obligations. You might have been quite willing to extend credit in previous times, but you may now wish to revoke that credit. You may wish to get prepayment. You may wish to get other security. I've talked all about contractual rights, but ultimately, if your customer gets wound up, those contractual rights aren't really going to give you much more than a claim that you can lodge against a liquidator and get in line behind everyone else. I do want to think about force majeure under a new contract. Now, a lot of people would just probably be thinking, oh, we've got to make sure we have a force majeure clause in our contract now. That won't be enough, because it may well be drafted in a way that either completely lets people off the hook for all COVID-19 impacts, even the ones that are 100% known at the moment, or it may not give them any relief against COVID-19 impacts when that's the intention of the parties. So think about it. You could have a force majeure clause that just says a party's removed of their obligations to the extent that they're unable to perform them due to an event beyond their reasonable control. Well, that's just saying if COVID-19 gets in the way, you don't need to perform your contractual obligations, even though you know at the time of signing this contract that COVID-19 will impact. So that's probably not satisfactory. You could have a clause that says refers to unforeseeable events. Now, the current level of COVID-19 restrictions are unforeseeable. I would say that it's probably at least, a possibility that there'll be a second wave, even if restrictions are lowered over the coming months. Who knows if there'll be another spike and we need to see further restrictions in place. So what is currently foreseeable is a very difficult question. You may expressly say performance due to current restrictions are not excused, but any performance due to future restrictions are. Or you may go the complete other way and say the supplier enters into this contract and both parties enter into this contract knowing that COVID-19 restrictions are in place and future restrictions could be put in place. Neither party will be excused from their obligations due to a COVID-19 type restriction. What I'd say is don't just skirt around the issue. Just be upfront about it and decide how you want to allocate risk and what you think is fair in this scenario. And to be honest with you, if it's a supplier who's taking on all the COVID-19 risk, well, they may set a price that reflects that. If it's a customer who's taking it again, if a supplier is being paid in advance for goods and services in this environment, and it's they're not having to take on any COVID-19 risk, that's probably worth something to them, and that may justify more, different commercial outcome. Let's think about the standard clauses. So you're going to normally have an Incoterm. You might always have been happy to supply goods on CIF terms, but all of a sudden, if international freight is becoming less reliable, there may be more risk of detention and demurrage charges. You may wish to change to FOB terms. Have a look at your termination clauses. What could you terminate if there's a change in COVID-19 restrictions? That may fall under a clause that's called a material adverse change. So if have a clause in there that says if there's a material adverse change that affects a party's ability to perform its obligations, you can renegotiate the price, you can terminate, the parties need to meet in good faith. You could have a variety of ways of dealing with that. Similarly, if there's a variation or change of laws, that could prompt a series of events that alters the contractual relationships between the parties. You could start pricing on cost plus type pricing. If at the moment you just want to guarantee a certain return and you're prepared to give that transparency. Otherwise, you might be able to have an ability to adjust your prices regularly and not be locked into one price for an indefinite period of time. Maybe it's monthly price adjustments with the ability of either party to terminate if they don't agree to the adjustment. Be very careful of any minimum volume spends or periods of contracts. That's going to be a commitment you may not wish to make in the current environment. And if you do sign up to those commitments, do make sure that you give yourself the ability to get out of those obligations if there is a material change. Have a look at limitations of liabilities and exclusions. If you're the party that's more likely to be the victim and suffer loss due to a COVID-19 style default, make sure that you've got an ability to take action against the other party. If there's a complete exclusion of liability, often these exclusion clauses will say for breach of contract. So if there's a complete exclusion of liability, then to be honest, a lot of the other clauses in the contract almost fall away because there isn't that ability to enforce a penalty for non-compliance. And also look at dispute resolution. If disputes are more likely, think very carefully about how you want those disputes resolved. Is it arbitration, especially if international contracts? If you're going to have your dispute being resolved by arbitration held in Singapore and you're in the US and the other parties in Europe, I mean, how realistic is that likely to occur? Other issues, what I'd really encourage people to do is really have a mechanism in contracts for having regular communication about COVID-19 type issues. So really try to look at, but it's hard to impose a partnership type arrangement. You don't want that. You're independent parties, each trying to get your own financial gain. But you can impose regular sort of meetings and communication about how to deal with COVID-19. You can impose obligations on the other party to respond within certain timeframes to changes in the law. So think about those in the sense of it's not business as usual, and what do we need from our other contracting party if things change? Some of the procedural type things, think about execution clauses. It's not uncommon for contracts to already be signed by way of counterparts. That's where each party signs their own version of the contract and they exchange that. They don't all sign the one contract. Electronic signatures are also very common, but just make sure that your contract doesn't require it to be sealed in a certain way or originals to be signed if that's now impossible. Just thinking about payment, we saw the currencies go all over the place last month. I think the Australian dollar got into the mid-50s against the US dollar. Just obviously pay more attention to be aware of that currency risk. If you have a credit account, think about when those credit terms can be changed. Sometimes they can only be withdrawn if there's a breach of contract or the like, so be careful of that. You may be asked to give directors guarantees. If that's the case, you may not be able to get out of it, but you may be able to cap your liability. So have a think about whether you want to cap, there's an ability to say, I'll give you a guarantee, but I'm capping it at 50,000, 10,000, 5,000. Just not an unlimited guarantee is probably a good compromise. And look, different countries will have different rights in respect of obligations to secure payments. In Australia, for instance, and in New Zealand, we have the ability to register a security interest over personal property. That's basically most things other than land, and that can give you the ability to enforce rights and basically sell that property if that property, I guess, has been used to secure performance under a contract. So we're seeing more and more contracts that have these security interests that say the customer basically charges all their real property in favour of the supplier to secure the performance of obligations under the contract. Okay, I might just move on to the end there, given the time. Collins, I apologise that I ran over there. And look, this last slide just echoes what I said at the start, that we need to pay more attention to contracts now than we ever have before, because things are more uncertain, and the contracts there are to resolve that uncertainty and to deal with disputes. And I think what we can say is that the likelihood of a dispute and the likelihood of things not turning out the way we expected them to is probably higher now than it ever was. So it's more important to have those difficult conversations now at the time of entering into the contract than to deal with them at the end or at the time when a dispute actually arises. So Collins, I know I've taken us to 11, but I'm happy to answer questions if people can stay on the line a bit longer.
Thanks very much, Russ, and fascinating stuff. And I think the reality is, as is always the case with issues that are quite complicated and complex, this is just scratching the surface, and we could probably have been on the line for another hour and still not have covered everything that needs to be covered. I haven't seen any questions being posted, and I am aware that people are probably a little bit overwhelmed by the amount of information that they've been given. So what we might say is, if you have any questions, you can see Russell's contact details there. He's very kindly given his email address and his phone number. And the next slide, you'll also see my contact details and Lisa McCauley's. So if you have any questions that arise after today, and I'm sure that's when the questions will arise, when you've kind of worked through all of the stuff in your head, and you might encounter some issues in your daily business life, feel free to drop Russell or myself an email, and we'll attend to those queries as much as we can. Obviously on the legal side, Russell will be able to answer all your questions. If you have any general business questions, if you have issues around exports, imports, just general terms around how you're conducting your business in these rather unusual times, feel free to drop me a line. If I don't have the answer, I'll find somebody who does. Please, I'm sure that you will virtually join me in thanking Russell Wiese for his time today. It's been fascinating, Russell. Thank you so much. Thank you for taking the time to be with us. And we look forward to having you on future sessions.
Thanks, Collins.
Thanks, everyone. Stay safe, and we look forward to your company at our next session. Thank you. Goodbye.